I've got us right at 9 o'clock, so why don't we go ahead and begin? Is it Marshall Crawford? We're good to go?
Okay. Yes, sir.
All right. Well, welcome to the New Wave Oral Argument session of the 5th District Court of Appeal. I normally would start up by asking people to turn off any electronic devices, but if we do that, we're all in serious trouble. So we'll just do the best we can. If you got screaming kids or anything in the background flushing toilets, that's all right. We'll deal with it. We've got two cases in the docket. We're doing them separately so that it's really irrelevant to you, but you can see I'm Judge Cohn. We've got Judge Lambert and Judge Edwards on the panel as well. We've got the clock in what's in my middle upper screen, and it reflects 20 minutes each for argument. If the appellant would like anything other than 5 minutes for rebuttal, let us know. We'll be glad to accommodate whatever you would like for rebuttal time. But that said, we're ready to proceed with Pritchard versus Pritchard 19-243. And Ms. Harris, you're the appellant. You may proceed.
Good morning. We're here this morning on two issues concerning an award of permanent alimony. And I think I'd like to begin, if I could, with reviewing the trial court's findings of fact in support of the permanent alimony. And some of the argument overlaps because in large respect, our position is that the standard of living that was established by the parties during the time that they were married, and we agree with the court's finding that it was a modest standard of living. But what we contend that the court has done is then awarded permanent alimony in this moderate length marriage, depending on whether we're using the date of separation of the date of filing. We're in that area of 11 to 12 years. So we have a moderate term.
Right, but that determination is subject to an abuse of discretion by the trial court, is it not?
I'm sorry, I'm not. Are you referring to the length of the marriage?
Or no, the length of the marriage is what it is. But if the judge could decide to, under the facts and circumstances of the case, to set that at the time of separation, at the time of filing, at the time of the final judgment, correct?
I would suggest that the standard of living needs to be the standard of living that's enjoyed by the parties.
Talking about the length of the marriage, because there was a gap between separation, filing, and final judgment, correct?
Absolutely, I agree. That's not so much our concern with the final judgment. The final judgment, in short, we believe that the trial court, in making its determination regarding the standard of living, has used the post-separation, the time in which the parties wouldn't have enjoyed the standard of living together, to make its determination as to the permanent alimony award here. Because when
that's the point of the question. Is it an abuse of discretion if the judge determines to go with the time of the trial for that determination?
I think it has to be. If your reference is the standard of living, I think we would agree that the standard of living is based on what the parties enjoyed together. If they have been separated, here my recollection is that they're separated almost 3 years before the trial is held, because they separate in 2005. In essence, they never lived together after a deployment to Tampa.
2014.
2014 begins the deployment. It ends in 2015.
But you said you said they separated in 2005. They separated in early 2015.
Oh, I'm sorry. Either I misspoke or I meant 2015. Yes.
14.
14 is the deployment. When he returns in 15, they are no longer living together. So it's arguably, arguably there's that period of time where they are, in essence, there's a separation, but there's that official, we're no longer living under the same roof in 2015. But I would argue that that standard of living has to be based on what they enjoyed while they were married. And when we look at what was their finances at that time, and much was made of this in the answer brief, that we can't go back to the time in which they were paying paycheck to paycheck. But when you look at what the income was, we're talking about virtually the same income into that household.
But isn't this really more of a legal error as opposed to abuse? I mean, the judge makes a fine. He says, in making a determination as to the type and amount, this court considered the testimony and the latest financial information of the parties. So, I mean, if they, using a hypothetical, if they separated in 2012, they file in 2018, husband was making $70,000 in 2012, and he's making $700,000 in 2018. The judge shouldn't consider his $700,000 a year income in 2018, would he? I mean, that would be legal error, wouldn't it?
Well, I would agree it would be legal error. I think the determination, and this is kind of, I've struggled since yesterday what to call this, because there's sort of a whitewashing of what is the ability to pay, which clearly he has an ability to pay, but that doesn't dictate what the standard of living was. And I think that's kind of what the trial judge did here. He sort of whitewashed this whole thing, because when we look at what they were, the standard of living they were living in, by all intents and purposes, she maintained she's a thrifty shopper, they've had financial problems. And when we look at the time in which they short sold their house, he was making $154,000 and change. And at the time that they separate in 2015, he's making $134,000. Now he does have a year, in all transparency, he has a year in there in which he does better than that. He makes about $171,000. But the standard of living in which, that they had at the time that they were married is vastly different than what his income was at the time of the trial in 2018.
Let's talk as well. So that really goes to the amount of alimony that is awarded. You also take the position that the award of permanent alimony was an abuse of discretion. Give me your best case that you think supports your position that this is an abuse of discretion.
I don't know that other than it needs to be supported by, there has to be adequate findings for you to do your appellate review to determine whether that was an abuse of discretion. And all we have here, Judge Cohen, is there's a modest standard of living and a disparate income. That's all we have, because the judge found that they've equally contributed to the marriage. There are no other findings here to support.
She stayed home and took care of the kids. And he was the breadwinner. So in that sense, this was a fairly traditional marriage. So how is it an abuse of discretion if the judge decides to grant permanent alimony?
Well, I would suggest that the judge didn't make the finding that you're asserting, because he finds only that there's a modest standard of living and there's a great earning difference in the earning capacity. He doesn't find that they made an agreement that she would stay home, that
there was evidence that supported that.
But without the findings, we can't determine whether the judge accepted those findings, found it credible, didn't find it credible. You can't make that appellate review that you're now tasked with, because we don't have the findings. He doesn't give it a thumbs up or thumbs down as to those particular findings, particularly the ones that are asserted in the answer brief, where they've gone through a series of potential criteria that the judge doesn't find. He makes no finding regarding any agreement, makes no finding regarding her personal career sacrifices. None of that is found by the trial judge.
And so you filed a motion for rehearing challenging the findings or the lack of findings?
The former wife filed a motion for hearing, and the judge makes in his order, he says the request for better findings is, and I want to misquote it, but in essence, he says that it should be granted. The request for better findings should be granted.
That didn't relate to the insurance, though?
Well, their requests related to the insurance. And I would say that when you've got a finding that is they've asked for a motion rehearing, asking for better findings. I would say that that issue is now preserved for the court to do a better job on its findings with respect to the permanent
Well,
element.
you've told us what the wife's attorney requested. I'm asking what you all requested in terms of finding.
The former husband did not file a motion for rehearing.
Right. And wouldn't that be necessary for you to preserve the lack of findings for appellate review?
I think that we're faced with a different scenario when we have the opposing party making a motion for rehearing, requesting additional findings.
As to one
Because
issue.
keep in mind there, and I'm sorry for over speaking, it's a little hard with this situation. They specifically note that the court did not make a finding as to which was the more appropriate of the alimony, and that in and of itself, I don't think the case law is saying you just need to have that buzzword in there, that buzz phrase, one is better than the other. And in this circumstance, that was sufficient enough for the court to support its finding that one was better than the other. And
okay, let's move beyond that and give me, as I asked before, your best case law to support the concept of abuse of discretion going beyond the lack of findings that this would constitute an abuse of discretion.
With respect to the permanent alimony award?
Yes.
In and of itself. Well, my question, and I don't mean to talk in circles around you, Judge Cohen, but whether this is a permanent alimony case or not, I think you're in a position that you can't make that determination because you don't have adequate findings. You have nothing more than a modest standard of living, which we don't contest during the marriage. Everybody says this. And then we have disparate earning, and we know by the case law that that's not in and of itself sufficient to stand alone.
Well, but we have read the record. We've read this transcript, so we know what the evidence in the case is. And so really, I'm still asking you for what your best authority is for the concept that this shouldn't have been a permanent alimony case. They asked for permanent alimony. Your client requested that the alimony be durational. What's your best authority for this being an abuse of discretion?
And again, I feel like I'm not answering your question directly. I don't know if it is or it isn't.
That's why I asked it 3 times.
I don't know that we can or we can't because we don't have adequate findings. Had the court made
let me suggest this. What if you assume or take that the court found essentially what the appellee argues in her brief, that she did give up her career, that she did stay home, that there were those agreements. I mean, if we sent it back hypothetically and the judge basically found what is asserted in the appellee's brief, how then could we find that that was an abuse of discretion?
Well, I think your question, because there's even a comment in the, or there's a sentence in the answer brief that says, if this is believed, then that's a sufficient finding. And that's the crux of this.
That's what I'm asking you though. If we did believe it, and I think just because there's evidence there, if we go back and look at the evidence and decide what we believe, are we reweighing the evidence improperly?
Absolutely. I think that's exactly what would happen because Judge Turner here had the opportunity to be, and I think we could even go so far to say that because he didn't make that finding, he didn't accept the testimony.
I don't know about that.
With the lack of findings.
It seems to, are you suggesting then that you don't, sometimes we ask people, well, how would this opinion read? Are you suggesting to us that we should not write an opinion that says the award of permanent alimony was error in this case?
That you shouldn't write that?
Right. That's what it seems. It seems that's what you're saying, that because there are no sufficient findings, the most we could do as a court is to remand this for proper findings. And then I guess hypothetically it could come back up on appeal on the issue of whether the judge should or shouldn't have awarded permanent alimony. So are you suggesting that we would be reweighing the evidence if we wrote an opinion that said the award of permanent alimony was an abuse of discretion in this case.
I think that you have two options is how I see it. You have the option to say, based on the findings that we have, a disparate income in and of itself is insufficient to support a permanent alimony award. Or alternatively, you have, because I think that's what our case law tells us, in and of itself, it's alone. And the only other, I'm sorry, I can't hear you.
It's really hard to get you to answer a question. I'm asking whether you think that we have the authority to author an opinion that says that the award of permanent alimony in this case was error.
I think you do. I think there is authority, because I think all we have is disparate income. That's all we have.
And now give me your best case law for that proposition.
I don't have it on my notes in front of me, but I've cited in my case law, the case law that says in and of itself, standing alone, disparate income is insufficient. And if you give me just a second, or let me answer it on my reply, I'll give you that case law that's cited in the brief about disparate income in and of itself.
All right.
But alternatively, I do believe that you have the option to say, based on this record, there's insufficient findings to support the alimony.
But if we do that, then it's a remand for the court to make those findings, right?
Yeah, I think so. I think that, and then the court is left with the job that Judge Edwards was referring to, make the determination whether the testimony is credible and whether the testimony supports the position that the court now has reached. And
that's what Judge Edwards is asking. If we remand it and the judge makes the findings consistent with the appellee's brief, how is that then? And now that's kind of addressed your primary discussion this morning. How is that an abuse of discretion then with the award?
Because I think that confuses the roles of the two courts, because there's, for example, with respect to the children, I would suggest that it's very, very likely that the court did not find these children to be special needs, and these children are very different than the children in the cases in which the
that's a child support issue, unless there's evidence, which I don't think there was in the record, that this child could never be self-sufficient.
But the appellee asserts that as a basis in support of the alimony award, was that these children are special needs children. And I would suggest to you that that's not what the evidence supports. And I would say, based on that, that's not what the court, based on the lack of finding in that respect, is certainly the other argument that the court rejected that testimony and found that they were not special needs children.
All right, you're into your rebuttal time. If you'd like to reserve the remainder of your time.
Yes, sir, please.
All right, very good. All right, Mr. Dorfman.
Good morning, Your Honors. My name is Charles Dorfman. I'm here on behalf, along with co-counsel Maureen Matheson, on behalf of the appellee cross appellant Stacy Long. When you look at the judgment, Judge Turner did what he's required to do. He analyzed alimony in the sense that he made a determination as to whether the wife had a need for alimony and whether the husband had an ability to pay alimony.
Mr. Dorfman, let me ask you this. You've got about an 11-year marriage, and let's assume, for the sake of discussion, that the former wife has the normal life expectancy, which would put her, I think right now for women is around 80 years of age. You would have then what was effectively an 11-year marriage, where I think, if my calculations are correct, not counting the alimony that she's gotten for a number of years now, she would have been entitled after judgment for 33 years of alimony on an 11-year marriage. Does that make sense to you?
Well, Judge, I think when you put it in definitive terms like that, you can easily step back and say, but remember, alimony, even though it's permanent in nature, does not necessarily continue for the rest of someone's lives, because there's changes.
Well, it does until something happens.
Such as retirement and things of that nature. I agree. So that's why the court requires that the The law requires that the court determine by clear and convincing evidence that this is appropriate and that no other form of alimony would be appropriate, which is what the judge did in this case. So the question becomes, did he abuse his discretion? I'm not aware of any cases that have discussed in a moderate length marriage the fact that someone may live to a certain age that is a basis to find the court abused its discretion. I am aware of many moderate length cases where people have been of similar age where permanent alimony was determined to be appropriate. And we cited several of those cases within our brief. But the issue—
This case, you know, there was testimony from the former wife that, you know, she wanted to go back to work. She had worked in the past, both as a real estate appraiser and in other capacities. She testified that she wanted to go back to work. I mean, why wouldn't a durational award of alimony and perhaps a placeholder of permanent alimony in a nominal amount have been more appropriate?
Sure. If you look at the wife's earnings history, she earned $7,500 during the marriage, was the most she ever earned. And I wanted to point out that the record when getting ready for today is missing Respondent's Exhibit 9 in evidence, which was the wife's Social Security earnings history.
Well, if you wanted it, you had an opportunity to have it included in the record. So since it's not, we're not going to talk about it.
Well, the wife's testimony actually covered it as well. We went through detail as to what the exhibit is, and she earned approximately between $700 and $7,500 many years ago in the marriage. Prior to the marriage, she earned just over $30,000. So when you look at the issue of durational alimony, which is something that since the legislature created that statute, I always describe it as there's a potential cliff. A person gets support for a period of time, they get to the end, and now they fall off the cliff. Does that mean they've become self-supporting at that point in any shape or fashion? And I would suggest that in this case, if you actually look at the financial records of the parties, the history as to what's occurred as the judge did, the court's award is appropriate. So in this case—
What evidence is there that she can't hold at least a minimum wage job, especially once the children are out of high school?
Sure. So the judge commented on that actually, and he said it appears she could obtain some fruitful employment presently. However, petitioner brought no evidence forward for the court to consider for the purposes of imputation of income. Additionally, the judge found that the parenting plan that the parties agreed to themselves was not conducive to the wife working. So
I'm talking about when they're— I understand now, and it is an unusual situation. We're not talking about somebody just looking after the kids for the afternoon. It could be days and weeks if he gets called back up on reserves. But talking about after the children are out of high school, do you really need evidence to say somebody who's physically healthy, mentally healthy, and who has worked in the past can't get a minimum wage job?
Well, I don't know that there's the ability to impute income at a future date in the present analysis of the case.
Well, if you look now, though, she has the ability. The only hindrance to her doing that is her testimony that the kids need her at home when the kids come home from school. So, I mean, it's not a question of ability. It's right now she has, if you will, a roadblock. She can't go to work now because of the kids. According to the testimony, I don't know that there was not a specific finding of that, though, was there?
The judge did make a specific finding that the parenting plan was not conducive to the wife being able to work at all. The judge did find that. And then he also, more importantly, commented on the evidence in the case. The husband did not bring forth any evidence regarding job availability, wage earning capacity, jobs in the community, even any of those factors, which is evidence that's required in order for the court to impute any type of income.
I think part of, if I understand Judge Edwards' question, it's not so much whether there should be a current imputation of income. It's really goes to the appropriateness of the award of permanent alimony.
Well, we would be speculating on what the wife could do and what she could earn in the future. We take people as they are now when we evaluate the circumstance. If in the future circumstances change, there is the ability to seek a modification of alimony. That's why we— But
you could do that. Couldn't you do that with durational alimony as well?
In what sense? Amount or duration?
Duration.
Well, duration can't be extended absent of showing the exceptional causes, so, or exceptional circumstances. So if the court assumed now that the wife would be able to earn a living commensurate with the marital lifestyle, and she did not, that may be a very impossible challenge for her to then extend the alimony in any shape or form.
Well, but the judge could have put a placeholder for a nominal amount of permanent alimony for that eventuality.
Judges have discretion to issue rulings, and that the judge considered that, and he determined that permanent alimony was the appropriate form in this case. We're sitting here looking at the abuse of discretion standard, which you've mentioned with opposing counsel. And I mean, the court analyzed each factor under the statute, made the conclusions. There is almost really the evidence is pretty clear in the record, because other than some conclusory statements by the husband as to the wife was spending more now, he didn't present any evidence to challenge what the wife has presented as far as her needs, and his ability to pay is based upon his actual income. There was no dispute as to that.
Well, let me add, do you agree with Ms. Harris, the parties separated in 2015?
I agree that they began living separately. However, they continued to jointly bank together, pay bills together. And in fact, the husband testified that in early 2016, they sat down together because he wanted to know whether the marriage could continue or not. So physically, they were not living together when he returned from deployment.
But he was
bought a house.
He was supporting her, paying $5,000 a month.
No, sir. When he returned in 2015, the parties continued to jointly live out of his earnings. It wasn't until the spring of 2016, when he filed the divorce case, that he told her he would make $5,000 a month available to her.
Okay. So in 2015, he's making $134,000 according to the record. And now the judge says, okay, I'm going to consider his latest financial information for determining amount and type of alimony. And at that point, he's earning twice that.
Actually,
is that either not a legal error or abuse of discretion to use that figure? I mean, what if he was making $2 million a year? You'd say that's fine. And
so that's a good question. So for child support, do we use his income presently, or do we use his income as it was at some point in time? When we look at somebody's ability to pay, it's their present ability to pay when the court is making the analysis.
Well, I agree, but I think Ms. Harris's argument is saying, okay, fine. If he's making $2 million a year, he obviously can pay $7,000 a month, but that's not pertinent to the amount of alimony based on the standard of living that people enjoyed. I mean, what if he won the lottery? And got...
No, let's talk about that for a second. So the appellant's brief outlined adjusted gross income on tax returns. And I believe that's what the court is looking at when you referred to $134,000 in 2015. However, you have to remember the husband in 2015 was deployed. So at that time, the record will show that in addition to his basic pay, which would be included as taxable income, he had tax-free income that does not show on the tax return. For instance, they were receiving an assistance to pay half the mortgage of the house in Orlando. They were receiving assistance to pay for their living and their subsistence in Italy, which is not taxable income. So when you look at 134, it also does not include his VA disability income that he's receiving, which is non-taxable.
But I mean, their standard of living, though, in 2014, we go back to that time frame. I mean, didn't they, in essence, get foreclosed upon, or they did a short sale to avoid the foreclosure? Is that inaccurate?
That's inaccurate, sir. So what happened was they bought a house at the height of the housing market, and the record is not clear, other than the husband acknowledges in his testimony the mortgage was being paid. They never did not pay their mortgage. They were not foreclosed. I would suggest what they did was they elected to unload a house at a point in time where the tax code allowed you to short sale and not claim the deficiency. In fact, the record, I'll give you the sites.
I thought that was the question that Judge Lambert asked you, whether there was a short sale, and you said no, and now you're saying yes, there was.
No, I apologize. I heard foreclosure and they weren't paying the mortgage. They did use the short sale process to sell the house, but if you look in the record, excuse me, the lights turned off. If you look in the record, 91 line 17 of the husband's testimony, he specifically stated that the mortgage was being paid. They were struggling with other bills that they
Didn't they have to take out loans in the neighborhood of $50,000 or $60,000?
He took a Bank of America loan of $48,000 and they took a personal loan from my client's mother for $20,000. They don't ever really describe what they used it for. However, it was paid back. The husband testified it was paid back.
That suggests financial difficulty going to your mother-in-law and father-in-law to get 20 grand to, I mean, nobody's suggesting they did it for a world cruise, I assume, right?
Sure. So let's talk about that then for a second. So if in 2013 and 14, the records show Mr. Pritchard's adjusted gross was 171 and 164 without his VA disability, which was about 20,000, I think the record shows. What is their standard of living that they're living at there? They're living off of almost $200,000 of gross income. Whether they choose to spend it wisely or not is a question. However, let's take a look at what really happened. This whole issue about living beyond their means. At the time of the divorce, the husband had acquired almost $400,000 in his retirement account. The parties kept their rental home in Milton, Florida. The wife owned a home and the husband had a home. They had 3 pieces of real property, $400,000 accumulated in retirement. And according to the appellant's brief, practically no debt, as they've claimed my client has run up debt post-filing. So have they really been living beyond their means? Their lifestyle was such that they were able to accumulate wealth. Between 2006 and the time of 2015, the husband started at $26,000 of income with JetBlue. And he increased that when you go to 14 before he left for deployment, he's up to $171,000. So we want to downplay the lifestyle. A lifestyle that requires spending of a little over $6,000 is not exorbitant. In fact, the husband said, I'm going to give you $5,000. Those were net dollars, if the court remembers. There was no court order. It wasn't deductible. In addition, the husband was paying the wife's health insurance at that point. So
but then again, Mr. Dorfman, that again goes to the amount ordered rather than the appropriateness of an award of permanent alimony. And and you're well aware of the recent legislative movement that to do away with permanent alimony. And it struck me as I read this case that this is the type of case that they're targeting, where you have not a short term, but not a long term. You've got 11 years of marriage, and then you're going to follow it up with over 3 times that length of permanent alimony. And that just strikes me as a very harsh result.
Well, the legislature hasn't changed the law. The case law is as we sit here. I can't predict why the legislature is choosing to do or not do things. As you know, the issue of the statute is debated heavily and what the outcomes could be in various situations. But what we're dealing with, I would respectfully suggest, is we have a judge that took the evidence, analyzed the evidence, followed the law, made the determinations, analyzed the factors, and reached the conclusion he did. And as you said, if we look at the record, is there competent, substantial evidence in there to support what he did? And the answer is yes.
We've never heard an appellee say that before. Let me ask a broader question. When the court looks at alimony, durational, permanent, whatever it is, for almost all the factors, you go back to the start of the marriage. What did each contribute to the marriage from day one? Did somebody give up a career? All the rest of that. Yet, even though the statute says you look at the standard of living during the marriage, the case law seems to suggest you don't look at the whole marriage, you only take a snapshot near the end of the marriage. What justification is there for that in statutory interpretation?
I don't know, would be my answer. I mean, they've analyzed, I guess the answer would be because when you look at an overall marriage and it progresses over time, you start seeing the fruits of the marriage as time goes on. This is a classic example where the husband was able to advance his career because of the wife's assistance. I mean, he was gone to New York for almost a whole month at a time. He was able to advance his career. When they went to Italy, he maintained his job at JetBlue, which allowed his seniority to increase, which shortly after they returned, he became a captain.
No, I agree with all that. And I'm not suggesting that you ignore the more recent time, but for the most part, You look at the whole marriage. I mean, you look at the current ability to pay and the current need. I get that, but you look at what did she do back when the babies were born, and how did she raise them, and this, that, and the other, going back to the start of the marriage. The statute doesn't say what was the standard of living during the last year or two, or when they filed, or anything else. It's what was the standard of living during the divorce. Why wouldn't you try to look at it all and consider it all?
Well, if you do, Judge, when they started their marriage, my client sold her home, used it to pay off debt for the parties. They bought a home in Milton, Florida, which is a comparable home to what she's in now. And she hasn't worked since, other than a few minor excursions there. And when she did make some attempts to enter the workforce, those were derailed because the husband would be away for extended periods of time. So I apologize. In reality, how my client is living presently, she bought an older home, it's smaller. It's similar to when they started their marriage. And you can look at, if I was in there saying she needed a 3,000 plus square foot house as they did in the Orlando area, you could argue, well, that was a peak, a anomaly in the marriage. But if you look at the very beginning, she went from owning a home to selling it, to investing in the marriage, to supporting the career, to living in a house that was not exorbitant, and she still is. She's modest, as she says.
Mr. Dorfman, let's just take a minute, because you're down to a couple minutes left, and talk about the insurance
Sure.
the procurement to secure the payment of alimony. I recognize that there weren't findings made as required, but really, isn't it his problem? I mean, if he wants to fund that by purchasing insurance, regardless of what it costs him, that's his problem as to the cost, as long as he produces proof on a regular yearly basis that he's actually secured the alimony through the insurance. Why should you guys care what he spends on it?
Well, I care because my client loses her retirement when he passes away, and if there's no life insurance in place, my client does not receive it.
He'd have to give her proof that there's life insurance in place.
As we pointed out, what happens if he does not provide the life insurance? An equitable distribution issue, there is no ability to really protect that award. And when we're talking about people paying for life insurance beyond age 60, beyond 70, we know it's cost prohibitive. It's not in the record because no evidence was presented. So the judge has elected to allow him to do something with no evidence, which would basically be a fanciful decision, as we described. And I think, one thing I thought about on that issue, if the court were to disagree and say, look, even despite the lack of evidence, we think the judge is allowed to explore that, then there's going to have to be a hearing, because it may be that what the judge is allowing him to do is an impossibility. He will not be able to get insurance on his life that will extend far enough into the future to cover my client. And the parties' marital settlement agreement says he's not allowed to impair my client's share of the military retirement. He should not do anything to defeat that. And we know, and I provided the Graham case, we know that the cost of SBP coverage comes off the top, which takes away a piece of my client's retirement. So when he designates his child or a new spouse, my client is paying for that coverage for the other person.
All right. Thank you, Mr. Dorf. All right. Ms. Harris, rebuttal.
And she has to unmute.
There we go. I promised you some cases, Judge Cohen. So I would cite to you Walker at 85 Southern 3rd, 553, in Carlton at 876 Southern 2nd, 1267, and finally Winder at 152 Southern 3rd, 836. Those cases speak directly to disparate income and as a sole basis for an award of permanent alimony, and the insufficiency of that as a finding. I also, Judge Edwards, I'd like to address your comment about the situation being different here for this particular couple with respect to their children. I think it's imperative in the analysis that we remember that these are school-age children. So the idea that my client would be gone for an extended period of time, these children are in school, and there's nothing in the record that suggests that these children would not be in school, and therefore she could work during school hours. So the idea that the parenting plan somehow prohibits that, there's nothing that prohibits. We're not talking about, for example, they cite in their brief the Green case. And in that Green case, there's so much testimony about that child's need for one-on-one care. We're far from that. We have school-age children that attend mainstream school, and there's nothing to suggest. And in fact, she says two things that I think are important. She says she volunteers regularly when the kids are in school, and that but for the children, she would like to work. Well, she has hours during the day in which she could work.
What evidence was presented as to the available jobs where she is for work during the school day that would generate how much income?
No, I agree with you that that evidence is not there. But I think that the task is, well, what do we make of a finding that the parenting plan precludes work, or that we're talking about couples that are different than most working couples today, where children go to school and both parents work during the day. There's nothing to set this family apart from what we see in the large number of cases.
How do you distinguish this case from the Cardillo versus Cardillo and the Hill versus, is it Houghton case, where you have basically couples rocking along in the last couple of years, the husband's career takes off and really starts crushing it, which is what you're trying to portray here. Those cases seem to suggest that you look at the standard of living right near the end of the marriage rather than overall. How do you distinguish those cases from this one?
Well, I think I would answer that one with the general comment that what I think has happened here is there's been a confusion between ability to pay and that being then establishing her need. And I would refer to Mr. Price's testimony when he's talked about the added charges that she has. He makes, well, we wouldn't consider that because it's reflective of need. So I would kind of blanket my question with that first, or my answer with that first. But what happens here is we don't really have a difference at the time of the separation. We have, by everybody's agreement, a modest standard of living, and we have income that's very similar. It's not until subsequent, and I would agree with Judge Lambert's comment that it would be almost as though he had won the lottery. And not in terms of the division of the asset, of course.
All right, take about 30 seconds and address the insurance, because we're running out of time on your presentation.
No, the case law tells us that the failure to award her the survivor benefits is subject to an abuse of discretion. And I don't think we have that here because her asset is secured. They may not like the means in which she's secured it, but it is secured, and the court has set in a mechanism to enforce that and to have that brought forward to say, you're not keeping the life insurance. And there's case law that says that marital distribution can be secured. Those are cited in my brief. They are, there's nothing out of this court. They cite, and I won't pronounce it correctly, Covinto case. That case doesn't overturn the other cases that permit insurance coverage on a marital asset. And I would suggest that they've not established an abuse of discretion by any means, because she is securing that asset for her.
All right, thank you, Ms. Harris. All right, thank you, Mr. Dorfman, Ms. Harris, for your presentation. And then, so we'll go ahead and end this session of court, and then we will pick back up at 10 o'clock for the next case. Thank you. Thank you both.
Thank you.